All right, this is case number 21 CR 83, State of Ohio versus Aaron Ann Taylor. Present for the state is Assistant Prosecutor Adam King, plus the defendant's attorney William Armentrout. You are Aaron Ann Taylor.
Correct.
Mr. Taylor is charged with aggravated possession of methamphetamine. It's a hearing of a motion to suppress filed by Mr. Armentrout on opposite. Are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor. Any opening statement?
Yes, Your Honor. So, the defense has filed a motion to suppress alleging that Officer Butler warranted the search of the vehicle violated the defendant's Fourth Amendment rights. I believe the testimony today will show that Officer Butler searched the vehicle was proper and no Fourth Amendment violation occurred. Just kind of give a brief overview here of what led to Officer Butler searching the vehicle and discovering methamphetamine. Back on October 11th of 20, the Hillsborough Police Department received a report of a male subject in a blue vehicle who was parked at Home 2 at Oldfield Station, passed out. Officer Butler and Officer Sharp from the Hillsborough Police Department responded to Oldfield. They located the defendant asleep behind the wheel of a blue Nissan. He was the sole occupant of the vehicle. Officer Butler knocks on the driver's window a couple times. The defendant finally wakes up. The defendant struggles to get the window rolled down. He gets it halfway rolled down, rolls it back up. Then he starts trying to open the door. He can't get the door of the vehicle open. Officer Sharp instructs the defendant to turn the vehicle off. The defendant does so. Finally opens the door and exits the vehicle. Once he's out of the vehicle, officers can immediately tell that he's impaired. He's stumbling around. His speech is slurred. His pupils are constricted. Can't hold still. Officer Butler starts speaking to the defendant. Officer Butler asks him if there's anything inside the vehicle that he needs to be aware of, any narcotics in the vehicle. The defendant replies that there are not any narcotics in the vehicle, that he doesn't want his vehicle searched. Meanwhile, the defendant continues to move around, keeps putting his hands in his pocket, eating a candy bar, talking with his mouth wide open. Then he tries to reach into the vehicle. At that point, officers place the defendant in handcuffs. So after the defendant's handcuffed, then he admits, he says, I have a rig in the vehicle.
So what?
I have a rig, R-I-G, which everybody in law enforcement knows a rig is a hypodermic needle. The defendant admits to having a rig, and he also then decides it's okay if officers search the vehicle. So after the defendant makes those statements, Officer Sharp calls the tow truck because obviously the defendant's vehicle is going to have to be towed. He's impaired, he's under arrest, nobody turn the vehicle over to him. So after the tow truck's called, Officer Butler begins searching the vehicle for the rig, needle, and also conducting an administrative inventory of the vehicle. And once that starts, Officer Butler locates the hypodermic needle in the driver's door compartment, and he also located a yellow rubber container on the center console that contained methamphetamine. So after Officer Butler makes that discovery, he advises the defendant of his Miranda rights. The defendant indicates that he understands his rights, and the defendant admits to the substance of methamphetamine, that he was a methamphetamine user, and that he'd been away for several days. So after that, the defendant was transported to the Highland County Justice Center. The vehicle was towed. That's the end of the story. When looking at this search, there are, I think, as many as 3 different grounds to justify why this search was proper. One, the defendant consented to the search. He told Officer Butler he could search the vehicle. 2, he admitted to having a drug abuse instrument in the vehicle. At that point, Officer Butler had a probable cause to search the vehicle. And 3, the vehicle was being towed, so Officer Butler needed to conduct an administrative inventory. So based upon all that, Your Honor, I think it's clear that there wasn't a violation here. The search was proper. Thank you.
Take over, Mr. Armentrout.
I'll wait, Your Honor.
All right, first witness.
Crime Butler.
Are you sworn in downstairs, Mr. Butler?
Yes, sir.
Raise your right hand, please. Yes, sir. You solemnly swear that the complaint you're about to give, you will do nothing.
Yes, sir.
And then Clark.
Sound the mic over. Can you please state your name for the record?
Yes, Officer Brian Butler.
And are you currently employed?
Yes, sir.
Where at?
The Hillsborough Police Department?
And were you so employed on October 11th, 2020?
Yes, sir.
And on that day, do you recall responding to the report of a male subject passed out in a vehicle with gas pumps in Hopefield?
Yes, sir.
Did Officer Sharp also respond to that call?
Yes, sir.
And Hopefield Station, is that located on South High Street in Hillsborough?
Yes, sir.
Is that in Allen County?
Yes, sir.
And what did you observe when you first arrived at Hopefield?
I observed a male subject passed out behind the wheel of a blue Nissan sedan.
Were you able to identify who that male was?
Yes, sir. It was Aaron Taylor.
Do you see Aaron Taylor in court today?
Yes, sir.
Could you please point to him?
Yes, sir. You're here.
Let the record reflect the witness and identify the defendant.
Door.
What happened next after the defendant was located asleep behind the wheel?
Officer Sharp knocked in the vehicle, woke the subject up. He had a hard time, tried to open the door, then he tried to open the window. It took him a couple seconds to figure out what was going on. Then he rolled the window down. Officer Sharp asked him to step out of the vehicle, and he complied.
Once the defendant exited the vehicle, did you notice anything about him?
Yes, his pupils were constricted, his speech was slurred, and he had a hard time standing still.
Did you ask the defendant if there were any narcotics in the vehicle?
Yes, sir.
What was his response?
His response was no, he didn't want me searching his vehicle at that time.
What happened after that?
The subject was putting his hands in his pocket, and he reached in the vehicle after we instructed him not to, so he was placed under arrest for physical control at that time. At that point, Mr. Taylor said, I was going to let you search, and he said that I've got a rig in there.
Did you make any threats or promises to the defendant in order to obtain his consent to search?
No, sir.
And when the defendant told you that he had a rig in there, what did that mean to you?
That means a hypodermic syringe or hypodermic needle.
Was a tow truck called for?
Yes, sir.
And why was that done?
Because he was under arrest for physical control.
What did you do after the tow truck was called?
I searched the vehicle to look for the needle and to complete the tow inventory.
What did you locate inside the vehicle?
I located the hypodermic needle in the driver's side compartment on the side door. I located a yellow rubber container that had a crystal substance in.
And after you located those items, did you advise the defendant of the Miranda rights?
Yes, sir.
And did the defendant indicate that he understood those rights?
Yes, sir.
Did the defendant make any statements to you?
Yes, sir. He asked me if it was ice. He acknowledged that it was ice, which is slang for crystal methamphetamine.
And was the defendant's vehicle towed from the scene?
Yes, sir.
And was the defendant then transported to jail?
Yes, sir.
No further questions.
All right, now.
Did you and Officer Sharp arrive in separate units,
Yes, sir.
exactly at the same time?
Officer Sharp got there probably maybe 20, 30 seconds ahead of me. He was knocking on the door when I got there, sir.
Okay, was he on one side of the vehicle and you pulled up on the other side, or what was the position of your cars?
He pulled up on the left side. I pulled up behind the sedan.
Okay, and then when you got out of your car, did you approach Officer Sharp, or did you stay on the passenger side of Mr.
I started off in the corner on the same side as Officer Sharp, and then I moved over to make sure there wasn't any weapons.
And you've testified that Officer Sharp was engaging Mr. Taylor, trying to get him out of the car, make contact with him, correct?
Yes, sir.
When he eventually was able to get him out of the car, where were you?
I was on the passenger seat, or on the passenger side vehicle, sir.
Were you actually in the vehicle, or were you looking?
I was looking in the vehicle from the passenger side.
Okay. Was the window open, do you recall?
No, the window was closed, I believe, on the sedan on that side.
Okay. And you've mentioned that there was a physical control charge and a paraphernalia charge that were filed by Officer Sharp, is that correct?
Yes, sir.
And any of the paperwork that was generated in connection with those two charges was prepared by Officer Sharp, is that correct?
Yes, sir.
And you later, after you seized the evidence, I know you had to send it away, but you filed an incident report, is that correct?
Yes, sir.
And then what we call a narrative, you typed that in, is that
Yes,
correct?
sir.
And none of that, if you recall, made it into the municipal court file, is that correct?
I don't believe so, sir. No.
And you had to send what you seized away to BCI to have tested, is that correct?
Yes, sir.
And you testified that He did not at first give you permission to search the car, is that correct?
That is correct, sir.
Do you recall when he denied it, was he already out of the car and handcuffed at that point in time?
No, he was outside of the car. That was prior to him being arrested for physical control.
Okay, may I approach the witness, Your Honor?
Yeah, nice go. Both of it.
I'm not going to mark this, Your Honor. Also, I'm going to show you what the title says, investigators. When you recognize that narrative prepared,
Yes, sir.
and it does have your name on the bottom.
Yes, sir.
And if I may also read it out so I can go on. Taylor was warned several times to stay still, keep his hands out of his pockets, correct? And he wasn't complying with that. That mean he wasn't
Yeah, he just kept putting his hands in his pockets.
making no aggressive moves towards you, Officer Sharp. He was just sitting.
Yes, sir.
Proper word, okay. Taylor attempted to reach in the vehicle. Officer Sharp and I placed Taylor in handcuffs. Is that about the way it went down? The next statement, Taylor then stated I could search the vehicle, correct? Okay.
So his words to you were, you could search the vehicle.
Yes, sir. He said I was going to let you search when we started placing him in handcuffs.
And the words you used were search the vehicle, correct?
Yes, sir.
And isn't it true, at no time did he give you specific permission to search that yellow container?
Not specifically the yellow container. He said, he just stated search.
And the time you began your search, he was in cuffs and was away from the vehicle, at least some distance, is that correct?
Yes, I believe he was on the left side while I was searching in Officer Sharp's vehicle, sir.
And was Officer Sharp still maintaining control of him after he'd been in cuffs?
Yes, sir.
Did you advise him of his rights, or did Officer Sharp?
I did, sir.
Was that before you searched the car?
Yes, sir.
Okay. Isn't it fair to say at that point in time he was cuffed, you read him his rights, so he was under arrest at that point in time, correct?
Yes, sir.
One second. And in connection with the search, you also fill out a motor vehicle inventory report?
Yes, sir.
Might go to witness.
Is this the inventory report that you prepared?
That's what I was sure.
The reason I asked is I couldn't read the signature.
That's all.
Sure you're right?
And you testified also about that at some point where Officer Sharp was getting the defendant out of the vehicle, but you were on the passenger side of the police, is that correct?
Yes, sir.
How long were you over there on the passenger side?
Just a brief second.
And then you came back over to the driver's side and were interacting with Officer Sharp?
Yes, sir.
Where was the defendant, while you were searching the vehicle, where was the defendant at?
He was outside of the vehicle at one point, but at some point when I was still searching, he did go in Officer Sharp's cruiser.
Okay, and the Officer Sharp's cruiser, where was it parked in relation to the vehicle?
It was parked at an angle off the driver's door,
How close?
10 or 15 feet maybe.
And there's been some testimony about charges that were filed in Hillsborough Municipal Court, is that correct?
Yes, sir.
Who filed those charges?
Officer Sharp did.
You didn't file any type of report or affidavit regarding those missing
Not
charges?
just before, sir. No.
I
I have a couple, just trying to clear things up. You said that you advised him of his rights, and he said he understood it and made statements. Did he tell you about the rig in the car before you went into the car?
Yes, yes, sir.
So he was out of the car, and after you tried to reach in, and then when you handcuffed him and advised him of his rights, then he made statements that there's a rig in the car.
Yes, sir.
Okay. Did
Well, he actually made the rig statement before I advised him of his rights. I was asking, is there something in here I need
Okay,
to
you
know
made
about?
that before?
Yes,
Okay,
sir.
that's what I was trying to clear up.
Yes, sir.
All right. What was the reason that you asked him to, if you could search the vehicle?
Based on his pupils and the way he's acting, I believe there's a possibility of illegal narcotics in the vehicle, sir.
Okay. And then the standard policy that Hillsborough Police Department to tow vehicles of persons that are arrested for physical control and don't
Yes, sir.
have someone else to drive the car away.
Sometimes we do, sir. It just depends on the situation, sir.
No, I'm saying, the question was, is it the standard policy to tow a vehicle if a person is arrested and taken into custody for physical control or OBI, and there's no one else to drive the
Yes,
vehicle
sir.
away? Okay. And this vehicle was at a pump at the station?
Yes, sir.
Okay. So, then, the Hillsborough Police Department has a standardized policy for inventorying vehicles that are towed,
Yes, sir.
and the search was, for this was inventory done pursuant to that policy?
Yes, sir.
Okay. Now, any other questions based on what I asked?
None from the state.
I don't think so, Your Honor.
All right, make that down, Officer. Thank you. Any other witnesses?
So you guys, no other witnesses, Your Honor?
All right, Armstrong?
I have one more, Your Honor.
Okay.
We were going to call Officer Sharp based on Officer Butler's testimony. I don't think I do, Your Honor. I don't think I need his testimony.
All right. Argument, Mr. King?
Thank you, Your Honor. At this point, the court is obviously aware of what unfolded here. Just as I indicated in my opening, I think there are three different ways to justify the search here: consent, probable cause, and also administrative inventory of the vehicle. Any of those three reasons would have been sufficient for Officer Butler to get into that vehicle, locate the yellow container containing methamphetamine. Given that the search of the vehicle was proper, State would ask the court to remove this motion. Thank you.
Okay.
Your Honor, we don't, our objection was never that there wasn't grounds to search the vehicle. Our objection comes in the form of what if any line is there to be drawn with respect to containers within the vehicle and whether or not there's grounds to search that. Unfortunately, I have not been able to find it. It runs in my mind it was either the Ohio Supreme Court or the United States Supreme Court within the last year came down with more of a bright line on containers within vehicles, but I've not been able to find that particular case. But you know, the court has hundreds of times gone through these things, and it still seems to be not to be decided all when you cannot go into this car. Clearly, the evidence is at the time the vehicle was searched, he was not a threat to get at that container, to harm the officers in any way. He was cuffed and maybe stuffed at that point in time. I'm not sure of the timing if he was in the car when Officer Butler commenced the search. There's really no testimony to that one way or the other. Clearly was in control and under arrest. What I'm saying is fine, you know, search the vehicle, but not that yellow container contained within it.
Mr. King?
Well, my response to that, Your Honor, would be that when an officer is searching a vehicle based upon consent or probable cause or even inventory, they are permitted to open a container. So Officer Butler did here. Thank you.
All right. Well, of course, compared to rule, the court finds that the actions of the officer in entering the vehicle and seizing the items, including opening the one item that ended up having a crystal meth in it, were proper for three reasons, and I have a little different. My findings are different priority. I maybe didn't mean it as a priority, Mr. Campbell. I looked at it as this for this reason. Number one, I think that the officer had probable cause to believe that the vehicle contained contraband, based upon the observations of the defendant being passed out at the pump station, his actions in having difficulty opening the window, and his physical description. The officer testified that he believed that he was impaired because of it was based upon illegal narcotics or drugs in the car. And therefore that triggers the automobile exception to the Fourth Amendment requirement to obtain a warrant, the Carroll case and its progeny. And then as far as taking the search of the containers within the vehicle, if the container that is located within a vehicle could contain the item that is being looked for, then it is proper for an officer to go into that. I don't think that law has changed for many, many years. Secondly, even if there wasn't probable cause in the automobile exception, the Fourth Amendment did not apply. The officer testified this was an inventory of a vehicle that was impounded validly impounded because the defendant was under the influence, and clearly it was passed out at a pump and gas station, that he was not capable of driving if he hadn't been taken into custody, but he had been taken into custody. There was no one else to drive it away. Obviously, the station would want it to be parked in its pump, and therefore it's a valid impoundment, and the inventory of the vehicle is an exception to the Fourth Amendment. It's not a search. The Fourth Amendment implies that illegal search is here. Inventory, by definition, is not a search, and anything discovered during that is, and again, probable cause was established even prior to that. Furthermore, after at the time of the inventory, the defendant had made statements that are being challenged as being admissible that did have items in it. And so when the inventory was being conducted, when he found an item that based upon his own experience as well as the statements of the defendant to contain illegal substances, because he said he had a rig, so he had a rig that's under influence, and likely he had the substances that caused him to be in the condition that he was, and so that would be a proper search of the item once under the inventory exception. He could take the item, and then once he saw the item, it could contain an item that would be contraband, then that is proper. And then finally, the consent. Defendant gave oral consent. So based on those three reasons, the motion is open, and all the items will be admissible. All right. Anything further in this case?
No, Your Honor.
Let's see. We have another pre-trial on this, or just a trial date.
It's not till September 20th.
September 20th.
No more pre-trials. We have September 20th for trial date.
All right. So we need to. There's going to be a resolution. This will need to be before deadline.
Well, if I may, Your Honor, scheduling matter. And my client has indicated, I'm assuming that the offer from the state is still on the table. The recommended offer is community control of an application to drug court, which my client has indicated. I told him, based on what the court's ruling was today, that we had a good decision made, and he's indicated, if I may, that he would accept that offer.
Okay.
That being said, I'm not available on the 9th.
Well, what about when are you leaving next week?
Tomorrow will be my last day before we hit the 14th day where we come back.
What are you doing this afternoon?
Well, I'm with Judge Greer from 1 till 3, but I suspect that will be from about 1 to 1:15.
Well, we can do it this afternoon.
Are you able to come back there or anything?
I don't know what they do down there.
Well, see, he's at Massey House right now, and they're at FRS from till 3 o'clock every day. It's a transportation issue.
Okay.
I don't know if you're allowed to.
I ain't allowed to walk.
Yeah, because he's furloughed actually from Judge McKenna's court to Massey, so.
Right.
He has to go wherever.
Well, just call them and tell them you need to be back up there. Look.
Where's your ride at right now?
So you're out at FRS right now. How'd you get up here?
They brought me transportation.
All right. Well, I think they'll come bring you back. If not, call Massey and they'll do it. But let's just figure out, say, 1:45. And
I feel pretty comfortable with that.
okay.
So I'm on.
1:45. And what you gotta do is call out there, and because they're gonna come get you. Just tell them you gotta be back. At 1:45. Just tell them Harrington.
Well, I'm going back there anyway.
Yeah. So just call them and tell them, or when you tell them, go back and you say, look, I gotta go back at 1:45. Okay. Great.
Please rise.
Thank you.